Attention, North Carolina gun owners. I am Chris Dorr. I'm the director here for the North Carolina Firearms Coalition. I have important news and an action item for you, and it is imperative that you take action quickly. I'll get right to the point, and then I'll flesh it out a bit more after that so that those of you who want to know the details can get what you're looking for. Here's what's going on in Raleigh right now. Lawmakers have introduced what they are calling a constitutional carry bill, but it's not constitutional carry because this proposed legislation absolutely does not get government out of the gun rights regulation business. And that's what constitutional carry is. I am asking North Carolina gun owners to click the link with this video and email your state representative and urge them to fix House Bill 5 before advancing it any further, or we will not get true constitutional carry pass. We will only get permitless carry pass and a whole lot of other mumbo gumbo that is not what gun owners deserve. So please click that link and send off your email right away. But now let's get down into the details of this proposed legislation. It is painfully obvious to the members and supporters of this organization that the North Carolina General Assembly is hesitant. I think that's generously put. They're hesitant in their tendency to pass big, beautiful pro-gun bills. It rarely happens. You can remember all the work that we had to do to get the permit to purchase permit repealed. That being the case, the opportunity to pass real constitutional carry where government is cleanly booted out of the rights regulation business, these opportunities might only come once in the next 1 or 2 decades. That's why it's imperative when this pressure is built up that this General Assembly pass a solid and uncompromising version of this bill that has been passed now in 29 other states. Here's what we cannot do. We cannot introduce a bill that is deliberately watered down in order to try to appease Josh Stein, the gun grabber, and hope that it's so lame that he'll not veto the bill. That's total bullshit. And it should have never even been an issue had the General Assembly done their job last year when they had the votes to override Governor Cooper's veto if they had passed constitutional carry. What we need to do is pass real constitutional carry through both chambers of the General Assembly, put major pressure on the governor not to veto it, and when he does, wait for a member of the Democrat House of Representatives to be sick for a day and then ram a veto override through. Or there's probably a dozen other scenarios that we could entertain to get the bill passed. But let's drill down into the bill now. Some problems with this House Bill 5. A solid, robust version of the bill is what gun voters have consistently sent pro-gun majorities to Raleigh to accomplish, and it is what gun voters deserve. In its current form, House Bill 5 cannot be labeled as constitutional carry. This bill has major issues that must be addressed before the North Carolina Firearms Coalition supports this legislation. Here's a few of those reasons. Number one, the legislation maintains the crime of carrying concealed weapons other than a handgun. True constitutional carry law restores the right to carry any lawfully owned weapon under North Carolina law. The fact of the matter is that the government should not be interfering in the decisions that a lawful person makes when they're deciding which tool is the correct one to defend themselves and their families. The state of North Carolina has no business interjecting itself into that. So this bill does not do that. It maintains the crime of carrying weapons other than a handgun. That's just dumb. The vast majority of constitutional carry states in America are concealed weapons states. Number two, the legislation leaves the burden on the defendant, aka the gun owner, to prove that they have the appropriate defenses in law or else potentially face criminal penalties. Number three, the legislation bases who can and cannot carry a concealed firearm based on the standards set forth in 14-415.12, which is the criteria for obtaining a concealed handgun permit, rather than on Article 54A, the Felony Firearms Act, further restricting who can carry in North Carolina under the so-called Constitutional Carry Act. It really sets up a scenario to fail, because you'll have people that are open and legal to purchase a firearm under United States law, but who are disqualified under the arbitrary rules that the state of North Carolina has set up for their carry law. And it's just totally, you'll have people who are legal to own one, but not legal to carry one under the way they are constructing this. This is not constitutional carry. Number 4, the legislation maintains the unconstitutional duty to inform law that requires gun owners to proactively notify each and every responding officer that he or she is carrying a concealed handgun, and it includes a fine up to $100 for failing to do so. We believe, and we aren't the only ones, that the duty to inform laws such as this, they violate a person's Fourth Amendment rights. It's just a straight up violation. In fact, a lot of states have done away with this duty to proactively inform, and yet here they are maintaining it. This is the time. If we're going to do constitutional carry, you should be able to carry and then not have to notify law enforcement every time you're exercising your right. Moving on, number 5. The legislation contains, it pretty much straight up contains gun control. Currently, a person generally cannot carry a firearm into an establishment where alcohol is served. However, if HB 5 passes in its current form, a person will be violating the law if they are carrying and have one sip of alcohol while out at dinner with their family, or if they've had trace amounts of alcohol in their system from a previously consumed beverage. Now, don't hear what I'm not saying. Okay, I'm not saying that they should pass a law that allows you to be drunk and packing in public. But a huge number of constitutional carry states have pegged the prohibition standard on the intoxication prohibition. In other words, you can't be carrying a firearm in public under the state's carry laws while legally intoxicated. Another example would be if in those states you can go out to dinner with your wife or with your family and have a glass of wine or a beer with your steak dinner and not be a felon for also retaining your ability to protect your wife or your family or yourself. That's the way it is in a lot of states, but now they're making a new law here saying that that's a crime. Also, I'd have to double check, but I don't know if there's an exception in this new proposal here for being on your own property. To be very clear, we don't believe that alcohol is always and completely a justification to remove one's claim of self-defense on their own life. Those details get very sticky. It's an individual case-by-case basis. But again, I've been out to dinner with a man named Masad Ayub, who is arguably one of America's #1 self-defense carrying and lethal force experts. He lives down in Florida right now, used to be from New Hampshire. And we went out to dinner in Iowa one time, where I'm originally born and raised, and he ordered a beer with his dinner. We were all out to dinner. And this guy's been in a courtroom many times as a expert. And there he was drinking a beer, and he was certainly armed. Anyway, that's a problem that they're creating in this. And 6, the last thing I'll mention here is the savings and the savings clause and effect date of the bill. The bill ensures that prosecutions for offenses before the date of enactment are not affected by the new law. Okay, so if anybody's been convicted of a gun crime that is no longer a gun crime after this bill gets passed, well, they still have that on their record. And that's total bullshit. If this bill reverses convictions on persons previously convicted, they should be able to have their records wiped clean, and these gun charges shouldn't be stuck with them for the rest of their lives. Those gun charges are very damaging to your personal career, by the way. Anybody's ever tried to get a job that has a gun charge on their record, good luck with that. But that's what's going on here. This bill is not constitutional carry. It's watered down permitless carry. It is not constitutional carry. If the appropriate changes are made, however, to this bill, and we will be meeting with several of these legislators here shortly, we will gladly support this legislation as true constitutional carry. And I'll be right back here to tell you all about it. So here's what I'm asking you to do right now. With this video is a link, okay? If you click on that link, it will take you to an easy mobilization platform where you can send a pre-written email to your state representative urging them to fix this bill and pass real constitutional carry, not watered down permitless carry that was written to satisfy one guy, Josh Stein. When you legislate to the lowest common denominator, which is what they're doing right here because they didn't have the balls to pass a real constitutional carry bill last year when they had the votes to override the governor, you get a total crap sandwich. They know this, which is why they're trying to harness the national momentum of the buzzwords constitutional carry. But this isn't that big, beautiful legislation that gun owners deserve. It's a watered down bullcrap sandwich that isn't nearly what gun owners deserve. Email your state representative and tell them to fix House Bill 5 and pass real constitutional carry right away. After your petition has been submitted, you'll be taken to a donate page. If you can afford it, we'd love if you can chip in whatever amount you can afford. It's $5, $500, anywhere in between, to help us mobilize gun owners